No. Just once it's pushed, then
It goes automatically. Thank you.
good afternoon, Mr. Ballanco.
Yes, it is.
Thomas Ballanco. And we'll go ahead and do introductions down the line.
District 3. Judy Morris. Sorry, Judy Morris, District 2.
Keith Rose, District 1.
So I'm Trinity, District 5, Southern Trinity. Thank you. Terry Mize, District 4.
Okay, so we have 45 minutes for the questions. We will rotate around. There is one question on number 5 that there's been an addition, a part B to the question that you haven't seen. So with that, I think we'll go ahead and start off. And District 5 is representing the starting point of all.
The universe in Trinity County. Thank you. Question number 1. Please explain to us your qualifications and the elements of your career that you believe are especially relevant to the position of District Attorney. Also, please share with us why you are interested in leaving your current position and joining Trinity County.
Start off with a loaded question.
Absolutely.
Thank you. Well, I'm going to take this question in reverse, if you don't mind. It's kind of a short walk from what I'm doing now to the county, although I guess it's kind of the reverse of Neil Armstrong, a short step for a person, huge step for me. It is not my life's aspiration to be Trinity County District Attorney. However, I do see what I think is a need in the county for a fresh look in that office. And I think there are limited qualified individuals to sit in that seat. And in this county in particular, we have needs that really resonate with our community. And being a member of our community, I feel like I'm aware of what those needs are and open to the various members of our community. I often say that we're one of the smallest counties in California, but we have all the opinions, which I think is true. A lot of, let's call it intellectual diversity in this county. There's feelings all over the map, and I think representing all of those interests, which is really the role of a district attorney, is to administer justice for the jurisdiction, which in our case is the county, is an important consideration. And to do that, I think you need to know the community so that you can appropriately exercise discretion, which is really the crux of the district attorney's position. In terms of my qualifications, I've been a lawyer for 22 years, which is shocking to say that and write it. It's gone by quickly. Done very many things, limited prosecution, I will say. I served as the tribal attorney for the Pine Ridge Reservation, which is unfortunately also burdened with the kind of poverty that we sometimes see in our rural area. And it's not so much a poverty of the individual, it's just that when you have few people in very spread out circumstances, the ability to project resources to those far-flung districts is expensive and time consuming, and rarely is there enough resources to adequately and appropriately project services. And so being able to prioritize becomes a huge part of any supervisory role. And in that role, it's organized a little different. It's a tribal law scenario. So I wasn't a prosecutor per se. I supervised the tribal attorney general who served as the prosecutor. I did get to take certain cases. I certainly evaluated which cases to keep at tribal level and which to send to federal level. The tribe in South Dakota is a non-PL280, to spare you the details, doesn't have state law apply on the reservation. It's tribal law and then federal law. So it was my role to work with federal law enforcement and prosecutors to determine which cases we kept and which ones we sent out. And I think that was important to at least see that side of the equation. Most of my career has been as a defense attorney. And of course, the legal profession has become more partisan than probably it should be, just like sports teams or politics. You're this or you're that. The gray area in the middle is very diluted. And I guess that's a little more understandable from the defense perspective, where I'm hired by a client to advocate for that client. District attorney advocates for the people, the community. And so seeing how the system works from this perspective of defense counsel, I think I've learned a lot about how prosecutions work and how to make effective decisions in terms of application of sanctions. They told us a strange, I don't know, all of you had education. I know very few things probably stick with you, at least that's my case. They come back at strange times. But one of the things they always told us at West Point is that training is to be managers of violence, which is a strange thing to say. And yet, it is very true. And while most people equate violence and the application of violence with anger and some kind of fight, in the case of a professional officer, anger is the last thing you need. Emotion is the last thing you need. And, I thought about that as I was filling out the application, and really, a prosecutor is a manager of violence. I mean, the state is the ultimate application of violence. It has the ability to put a person in a box or put them to death in appropriate cases within the context of our laws. But that is an overwhelming responsibility, and one that I probably had more experience with than I wish I did. And I will bring that to bear on the county, on the county's behalf, if you determine that that's the role you'd like for me to play here. And in terms of switching sides, as it were, I've always taken the responsibility to advocate for justice seriously. Now, I certainly have advocated for my clients, and many of my clients have been guilty. And unlike a lot of defense attorneys, I've often known that my clients were guilty when I took the representation. Now, that doesn't mean I would suborn perjury, but it does mean I give an adequate and vigorous defense. So, serving justice on the side of the prosecution, allowing the application discretion, is something I look forward to, and I think I can do well.
Any follow-up questions? All right, question number 2. How many trials have you prosecuted or defended?
Good question. I tried to come up with a number, and I don't have one. I mean, my short answer is not enough, because trials are like the guitar solos in the rock concert of a lawyer's career. They are the best parts. I probably had at least 20, but not 50, so I'm going to say 25 trials. And that's, by that I mean a trial to a jury or a court. I've handled hundreds of cases. From a defense perspective, it's often not the best tactical decision to go to trial. I think a prosecutor finds himself in court a lot more often than a defense counsel does, particularly when you have clients that may have already revealed some guilt in the circumstances. Usually a deal is a better route, and that's why, you know, there have been many, many occasions when I was prepared for trial. I settled cases on the steps of the courthouse with the jury in the room. I enjoy trial. As far as trial craft goes, I keep that sharp through the administrative work I do. I've had hundreds of evidentiary hearings. The skills that are involved in trial, putting on a presentation for a jury, eliciting evidence through examination, making and defending objections, cross-examining, thinking on my feet. I do have those skills, and I keep those fresh. I certainly look forward to trials. I'm not litigation averse by any means. Like I said, I think they're really the best part of a lawyer's career, and I do enjoy being in front of a jury, because that really makes it real. And I think one of my professors when I was in law school she was the first woman appointed to the Supreme Court of Colorado. She happened to live in Boulder, which is where my law school was. So she volunteered to do our moot court. She was the judge for our practice trials. And she was a fan of the ballet. So she said one of these interesting, I'm giving you about all the things I remember from my education, but this is another good one. She equated trial to the ballet. She said the lawyers and the witnesses are the dancers. The score is the criminal procedures and the rules of court. The choreography are the rules of evidence. The judge is the director, and the audience, of course, is the jury. And, you know, I thought about that as I have gone through my career, and it kind of fits. You know, a trial is a show for the jury that moves through specific rules set to certain standards, and the judge makes sure those standards are maintained. And it is a performance. It is a very real performance, but it's a performance for the jury, leaving them with the ultimate responsibility of determining guilt or innocence, which is a huge responsibility as well. So I'm a good dancer. You know, every trial you have to brush up on your choreography, the specific rules of evidence that will apply to that trial, plus the unknowns, the known unknowns and the unknown unknowns. Those things all become part of trial preparation, all of which, like I said, I do enjoy.
Okay, Tom, how would you describe your relationship with each of the local law enforcement agencies, such as county sheriff, police, CHP, probation, CAL FIRE, Fish and Game? You know all of them.
Maybe my favorite question on the list. Thank you. And I think part of why you would pick me for district attorney, if that is what you choose to do, is to make a strategic reset on these very relationships. I think there is, and I don't mean this as to disparage anybody who I know is doing the best they can. I do respect that about the people who work in this county and for law enforcement. There's a certain stagnation, I think, has set in some of our procedures, and I think we could benefit from a reset of certain of those relationships. What does a crime look like? What kind of evidence do we need to begin the charging procedure? Where are our priorities? And those are the things that I think are the advantage of picking someone who is an outsider, and those are specifically the reasons I threw my name into consideration. Because I think it's good to change those up every once in a while and to look at the roots of those relationships rather than this is the way we've always done things, so let's keep going. That may be how it ends up, but I think starting at the beginning, what are these roles is important. I have, cordial relationships with most of those agencies. I know several of the people who are members of our communities. Part of why I have avoided trials in Trinity County specifically is because I didn't want to put some of these people in our small community on the stand and subject them to my kind of advocacy. It just, to the extent I could avoid that, I saw it fit to. So I don't think there's a lot of animosity there. I haven't dressed down any of our deputies on the stand. So I have a lot of respect for the local law enforcement and the ones, it's not an easy job here. And we have a lot of ground to cover and not a lot of dollars to do it with. So I look forward to working with those agencies to really prioritize our focus.
All right, number 4, Supervisor Myers.
What is your position on drug-related offenses and prosecutions of such if appointed?
Write this question for me.
It had nothing to do with any of this.
Good question. Great question for today, and I really hope everybody answers at least the part as relates to cannabis the same way. And that is, I think the district attorney's office should move out of simple cannabis enforcement. That means cultivation, that means possession, and the reason I think that for is, it's going to be a free-for-all. If we think of sanction, the sanction I'm left with, the hammer the DA has, I don't want to get ahead of myself, the sanction the DA has, it's like the hammer you can buy at CVS to keep in your glove compartment or purse. You screw the top on, and sometimes it's a screwdriver, sometimes a little hammer. Meanwhile, county council's sitting over there with one of these circus hammers that they can wield 5 times faster than the district attorney can. And by that, I mean Prop 64 essentially legalizes possession of cannabis and limited personal growth and establishes the commercial framework that we're all familiar with. It also reduces most cannabis crimes to misdemeanors. That means 6 months, $500 fine. After running through all the criminal procedures. And I will not refer to those as burdensome, but I will say they are time consuming and they take money and resources to put together a warrant, serve a search warrant, put together a case, have an indictment, have a plea. We're talking, each one of those instances costs time and money. Meanwhile, Prop 64 lays out for local jurisdictions, including counties, the ability to stand in the shoes of a state and enforce the state, in this case, largely the CDFA, but it would also be Bureau of Cannabis Control rules in terms of unlicensed commercial cannabis activity. So that means the same grower that after all those procedures, the district attorney could potentially stop with a $500 fine and up to 6 months in jail. County council could, with a letter, stop with a triple the licensing fee fine for every day of that violation. So for an outdoor grow of 10,000 square feet, I think the licensing fee is around $4,200. We're talking $12,000 fine per day. No trial, no procedure. It's like a parking ticket. I think a district attorney coming in at this time, I'll work closely with county council. And maybe it's the DA's office that wants to do that. It's available for county council, and I think that's probably more appropriate because it gives a little more flexibility in the administration, and it kind of works with our own county code enforcement arrangement. So I think an incoming district attorney should work closely with county council to develop an approach to what is essentially unlicensed commercial cannabis activity. It's not to say we're just going to throw the gates open, but I think we ought to use the sanctions that are available. Oh, and the resources expended come back from the state on that. So that's not county, but we probably have to front the money, but it comes back from fines collected from the fund that the state has. So that's a huge difference, just expending our law enforcement budget. And that's one of the things that often gets overlooked in Prop 64, right on the findings of why we need this law, is that we can apply limited resources to more serious crimes. And nowhere is that more true than here. And now that does not mean other crimes. Somebody threatens their neighbor, that's criminal threats. That's a different crime than cultivating cannabis. Somebody, is the whole host of environmental crimes associated, dumping in the creek, using banned pesticides, using banned root. Those are all crimes in and of themselves and ought to be charged as such. And on this subject, I will say it's certainly my intention to enforce all the laws. That said, every district attorney has to exercise some discretion, and that discretion is informed more often than not by economic considerations, not just dollars and cents, but hours and available personnel. As for other drug crimes, because cannabis is not our only drug problem here, as we all know, simple possession cases often get us down the Prop 36 route, which I was in favor of. I know a lot of defense counsel were for reducing the prison population and, getting people into treatment. Unfortunately, its success has not been as great as anybody hoped. It's probably better than nothing. It has reduced our prison population, but statistics I read recently, it's less than 40% of people who enter Prop 36 programs actually complete the program, and unfortunately the recidivism rate in even a year is rather high for Prop 36. Doesn't mean we have to, we can't use it. Of course, we're locked into certain of the parameters of Prop 36, but there's another shift here, and I forget the other proposition, I think it's 47, that changes some of our felony drug possessions to misdemeanor drug possession. Again, in the interest of reducing prison populations, which is a valid interest, and I think that certainly plays here for us. But it used to be, when the drug war started, drug charges were enhancements to other criminal charges because they could get you some extra time, get you some extra charging. They were often felonies. I think we've come full circle now where focusing on the drug offenses and taking away from other crimes, which we probably have better sanction against, if somebody is just using meth and cleaning their house, they're probably not having that huge impact on society. But chances are, they also might be breaking into houses, getting into fights, discharging a firearm within the boundary of a fire district, the kinds of things that amount to other crimes. So I think when we look at drug crimes, we need to look at other crimes as well, so that it's kind of a mirror of where it used to be. The drugs used to be an enhancement to the other crimes. Now, the other crimes are an enhancement to drug charges. So if we see somebody who's a serial meth user and, we put them through the program and nothing's happening, okay, but if they're also committing other crimes, we need to start charging those kinds of crimes as well and maybe put the focus there.
Okay. Okay. Number 5 is the one that's going to have a Part B that you haven't seen. Sophie, go ahead.
The first part's a standard question. Please explain how you have created an optimal working relationship with elected officials, county executive officers, city managers, department heads, local and state law enforcement, and other government agencies and constituents with whom you interact. What have you done to establish credibility and facilitate communications with them?
I endeavor to keep open lines of communications with really everybody, certainly with elected officials and other public servants. Try to be clear and concise in my communications, not always so good on the concise part. And I, endeavor to know the people that impact the community. So I like to make myself available and will continue to do so if I'm in this position. I have various areas of experience that have certainly brought me to the attention of some of your own elected officials. And, again, I try to be clear in my communications, modest. I'm fearless in who I interact with, so I don't mind talking to anybody, and that's why I have certain relationships with a lot of the enforcement personnel that maybe other people don't. I have a lot of contacts that I haven't leaned on before in federal law enforcement, mostly friends of mine who I went to school with who took a different track. And I would certainly tap some of those so that we could have a more balanced approach, I think. And I haven't been in the district attorney's office, so I don't know the approaches we use, but it seems like we could integrate certain other agencies more effectively. And I could be wrong on that, but that is certainly something I would look at.
Part 2 of the question is, have you had any interactions with the Trinity County Board of Supervisors, County Council, CAO, or current or past judges? Please describe your relationship with those parties.
Was that word interaction?
Yes.
Well, I think I've had interactions with each of you, certainly with the county council and with both of our judges. I've had cases in court. Our newest judge, who, like our senior judge, are both former district attorneys. I've taken cases in both of their offices with them on the other side, found them there. I think, our new judge, I have only appeared in front of once, so I can't really comment. I think our senior judge is excellent, takes his job seriously, and is always well prepared, and I feel like pays attention to the cases. I don't think he has a clerk telling him what to say. I think he actually makes his own decisions, and that's a benefit in any judge. make myself a pest to elected officials or county council. I don't know if that's as effective as I endeavored. I like to make myself available for questions. And I think I've done that well, and I endeavor to keep open relationships that way. I think communication at the county level is important, and I think it's easy to compartmentalize when you're dealing in an organization, and that runs risks of one hand doing this and one hand doing that, when there should be a little more coordination. And I would certainly like to see that from the district attorney's office. And I think that's an important role, not just for elected officials, but for the community.
Follow-up. A little time check here. We're behind schedule a little bit, so we have 15 minutes to finish up the last questions. Number 6.
I'll talk faster.
Thank you. Number 6, the victim of a very heinous crime wants to pursue charges that are only marginally supported by the evidence. Describe what actions you would take.
Good question. And this goes back to what I was mentioning about the dual nature of the legal system, where I'm representing the victim if I'm the prosecutor, I'm representing the defendant if I'm defense attorney. Prosecutor's client is the people. And that means until guilt is established, the defendant is one of the people too. Doesn't mean you have to minimize the victim, but a prosecutor is ethically bound to only bring charges that they believe the evidence supports. And sometimes that means bringing a lesser charge than the victim may want. It's a challenging thing. Certainly, victims have rights to be heard in all aspects of a criminal prosecution, but the discretion remains with the prosecutor. And, you know, like many ethical rules, this one has a practical component too. If you bring a charge that's not supported by the evidence and the defendant is acquitted, well, double jeopardy keeps them from being charged by something else. Part of the reason everybody knows the name of Emmett Till is because his killers were acquitted, and then they gave an interview to Life magazine about how they did it, because they were acquitted. So there is risk involved with bringing a case that is marginally supported, even if the ethical consideration weren't there. Certainly, I think interaction with the victim is important. It's a strange dilemma the case presents, because one would expect when you have a victim and a heinous crime, you would expect you have pretty good evidence. You probably have an eyewitness. But again, there could be alibi or something at the time. That's second question for you. But I think one has to keep their focus on the justice of the situation and apply their discretion as neutrally as possible. And that may involve a plea deal that the victim doesn't approve of. But that is, ultimately, that becomes up to the electorate again.
Thank you.
All right, number 7, if you're selected for this position, tell us how you will define your goals in your first 6 months as the Trinity County District Attorney.
Thank you. I think the first 6 months, I know I'll do one thing, and that is review every pending case and see where we're at and see what is occupying the most time and resources in our office. I'd also implement my own prosecutorial priorities, which would be violent crimes first. Include in that are, of course, all the sexual assault crimes and crimes against children. After that, crimes against the elderly, other felonies, which will include the majority of our environmental crimes, then misdemeanors and infractions. That's not earth-shattering in the hierarchy. What might be different is the application of resources to meet those priorities. I don't want to see us spending 80% of our time on misdemeanors when we don't have enough time left over to do an aggravated assault case, something like that. I'll ensure the office focuses its attention on the most severe crimes first and stages down. And in that sense, I think, and I don't want to get ahead of ourselves on the questions, that would involve me keeping the discretion function a little closer in the first couple of months while the office learns the priorities I would establish. Also in that 6 months would be that strategic reset. Meeting with all the agencies, getting on the same page, getting to the roots of our relationships, and determining how we're going to proceed, what kind of evidence we need, what kind of charges we prioritize. And I think also in that 6 months would be establishing with County Council the approach that the county will use to unlicensed commercial cannabis activity, and tying that in with CDFA and BCC to make sure we're all on the same page so that we can hit the ground running. Really, that becomes most appropriate after January 9th, when all the Prop 215 stuff goes away. There's still lingering gray area this season because collectives are still authorized until 1 year after the effective date of the Adult Use Act. So that expires January 9th, 2019. After that, I think we need a focused approach. So those would be my goals in the first 6 months.
Please describe your experience managing a county department, a major division of an organization, and provide examples of your management style.
Well, I haven't managed a county department, though in this strange hybrid that I would say the closest I've come was work on the reservation managing the legal department, which, again, looked at two directions because the tribe as a separate nation also had a relationship with the government. So in a certain way, I was managing the tribal relationship with the United States. And that job, their priority was sovereignty above all else, even above violent crimes. Issues of treaty rights trumped that. So they would rather deal with a murderer living on the reservation and give the state of South Dakota the right to come in and arrest them. That's a priority unique to that situation, but it was one I dealt with. Also notoriously understaffed, under budget. So the priorities become the touchstone for that management style. And my management style is when everybody understands the way the office works. I like to have a hands-off management style. I don't feel like I need to be micromanaging. However, at the outset, until that style and office protocol is understood, I think there's going to be a little tighter control. And as I mentioned, the first several months, I think I would probably make each individual decision about what prosecution goes forward before I start delegating that to ABAs, just so that we all understand each other. And once we do, I'm very much in favor of allowing the machine to work as it should. But you know, when you're the district attorney, your name's on all those papers, so I would certainly have to stay on top of the office that way. And whether I delegate a responsibility to someone else, ultimately it's going to come back on me. So I'm going to have to make sure that the priorities are very clearly understood. And when in doubt, I will retain that discretion myself.
Okay.
Tom, you have certainly spoken about your broad experience, whether it's on the tribal law, environmental, federal cases. You bring probably a unique training, your officer training through West Point. What will you bring under that level of education? What will you be bringing from a management style to the office that might be a little bit different than typically is done in most offices?
Well, I certainly have time management hammered into me, and part of what West Point does is they give you more than any human being can do, and the reason they do is to make you manage time. And so I'm used to managing the limited resource that is time, and also to handling the stress that comes along with that, and evaluating when people are being overworked, overstressed, too involved. And that's easy to do in legal cases. You can get too closely related to the case, and it wears on the human being. And I need those human beings to be the neutral arbiters of justice that they are. So I certainly will be able to keep focus on the task at hand, but also evaluate the people who are performing those tasks and make sure everybody is both performing to their most efficient methods, but not overworking themselves or getting too wrapped up in a case. Handling pressure and stress is just something that comes along with those jobs. I have developed a lot of techniques personally that work for me, and I certainly am willing to share those with the rest of the office so that we don't end up taking the job home and living it. And, you know, particularly like the heinous crime of a few questions ago, it's easy to bring things home from the office and really let that, and to a certain extent you have to personalize because you're giving that show to the jury. But at the same time, you can't overwhelm yourself. And so I think having had experience of intense management, of intense situations, I can recognize some of those factors. And I think that's an important consideration, and particularly as we talk about we have limited people to do these tasks.
Thank you.
Any other? Okay, Terry, number 9.
Management and administration of the DA's office budget is a key responsibility of the DA. Describe your level of fiscal experience and knowledge, in particular preparing, managing, and administering a department budget. Describe your fiscal management philosophy during these difficult budgetary cycles.
And that's a good question as well, thank you. It builds on many of the others. I started managing budgets probably not quite as big as the county's discretionary budget, but pretty big when I was 21 for a tank platoon. And it's probably, I don't know, it's not more responsibility than a 21-year-old should have, I suppose, because it worked. It's a lot of responsibility. It's kind of different because in the Army, you had a lot of money. And in that sense, the incentive was spend more than your budget is so that your budget gets raised next year. Now contrast that with the reservation, and there was never enough money. There just wasn't. There wasn't going to be enough money. We couldn't even pay the debts that we had. So you have to lean on the priorities, and that's why the priorities and what would be my enforcement priorities become so important. Because when you have limited resources, You have to apply your resources to the priorities and go down from there. And that doesn't mean at the bottom on the misdemeanor infraction level, we're not charging things. But there are alternative things, ways to charge, and there's ways to dispose of cases quickly. So with our limited budget, I would apply it to the top end of those priorities. And at the same time, look for other sources of funding, and particularly like this approach to unlicensed commercial cannabis activity. There's money out there from the state for that. Whether that means we hire somebody exclusively to do that, either in the DA's office or county council, we can do that. There's other funds for the environmental enforcement of cannabis crimes, which is another pot of money we should tap into, no pun intended. And I'd also like to see us work closer with some of the federal agencies on public land roads. It is unacceptable that we have organized crime running rampant in our county. It's just something that we have to address. We've got to tap into federal resources to do that, to include budgetary resources. And I think that's, county can't be expected to mount prosecutions like that on its limited budget, but we certainly can be a component in a federal program to do that.
Okay, follow-ups? All right, Mr. Ballanco, this completes your interview. Is there anything else you'd like to share with us relative to the position or your experience?
I don't necessarily envy your decision. And, I certainly am willing to undertake the role of district attorney, and I would do it well. And if it is in your esteemed judgment you think I should do it, I certainly will. I have, personal relationships with each of you. I am not going to hold it against you. If you think that somebody else is the better choice, that is fine with me. It is also fine with me if you put me in that role. So I leave that decision to you. I'm available if anybody has any further follow-up questions, and I'll see you regardless. Thank you.
Thank you, Tom.